Your Honor, we're here before you on a couple of matters. The first is that Mr. Jones is scheduled for PCC today. When I went over Mr. Jones's discovery, there was some sort of corruption in the file that I had. I contacted Mr. Childers to get another copy, because I do not have a copy of the lab test results. Mr. Childers indicated that there was some sort of issue with his as well, and he is attempting to get us both new copies of the police report so that we can.
At one point in time, this report worked fine because I remember reading it, but oddly enough, the machines emailed me. It's kind of corrupted on my end.
Okay. All right.
So we are asking for an adjournment, so we'll have more time to discuss that. In addition, it is my understanding that Mr. Jones was remanded last week on a bond violation.
Oh, he was.
What I'm not clear about is if that remand resolved the bond violation or if we are having continued hearing. We do have some additional information if the court would like that.
What is your additional information?
So I did email to Ms. Wilding a copy of my client's medical marijuana card that he had.
And as I indicated to counsel last time, the medical marijuana card wasn't a problem. It was whether he had a medical cocaine card.
That is okay. It was my understanding that community corrections did not have that. So I sent
The medical marijuana card? Okay.
That's correct.
They'll have
So they now have that. The other thing is that Mr. Jones is being represented by Mr. Jeff Bennett, or had been represented by his office in Lenawee County. And Jessica Kirkland of Mr. Bennett's office did contact Lenawee County. And I do have a copy here of where she received a photograph of what I believe is the most recent test that client took there in Lenawee County. And
which was what date?
that would be I believe, April 11th date, but I want to.
April or March 11th?
I'm sorry, I said April, but I meant March.
Okay.
With this, I believe that Mr. Jones, through counsel, explained last time that because of some issues with the test, that he had been bringing
His own test.
his own test,
Yeah.
testing there with them. So we do have, for your honor, the two copies. I
Is
received
that his test?
it's a picture. I have a photograph of both his test as well as the test that whomever the agent would have taken with him at the time. Ms. Kirkland apparently called Lenawee County and received from Agent Mike McCarran the photos that were in their file of the two tests. And I provided a copy to Mr. Childers.
But hold on a second. I have Lenawee County's test that shows he's positive for cocaine.
Correct.
Then I have a test that he brought with him that indicates that he's negative for cocaine.
That is correct. However,
Okay,
he did
so
take
which
the
one
test.
do you think I'm going with?
If I could say, it's my understanding from Mr. Jones that he took the test there and that it was under observation just like the test that they had taken. Is that right?
Yeah.
And that they opened the packaging and all of that. So I do have that, for your honor, that shows the negative screen.
He told me this the last time.
Yes.
And it still ended up in his bond being revoked. I have a test from a facility in Lenawee County. I have a test that he brought there. I guess I'm not even going to contest how it was administered. There are going to be different types of testing.
if you would like to see, his is the 5-panel test, and
Theirs was a what?
that is part of what his concern is in terms of when they're testing. It is it is a dipstick that is they only have in the urine for a short period of time, and then they place it like on a counter or something, he explained, and then they wait for the test results. So
He'd
where
like a
his
hearing, he can
remain,
bring all of them up, or if Lenawee County wants to say their test, that they're gonna take his test as opposed to their own test, then I'll be more than happy to hear their sworn testimony as to why they're doing that. But at this time, what I've got is I have a test that indicates that he's positive for cocaine from a facility in Lenawee County.
okay.
I then have the defendant's test saying that he's negative.
Well, at this time, Your Honor, we'd just like to address bond, if we may.
Well, does he want a hearing on that issue? Because I'll be more than happy to set a hearing.
No, he's indicated that he just wishes to address bond.
Well,
And part of that is, it is my understanding from him that he was not consistently tested by the same person, and
he
that
wasn't consistently tested by who?
the same person, the same agent, and therefore, and at least
Ms.
one of
Gates,
them
have
no
you
longer.
looked at this progress report?
I have, Your Honor.
He periodically comes up with cocaine in his system.
That is what
It's not like this was a one-off
That-
on March 11th.
that is correct. Okay, so again, at this point, he is requesting that we address the bond, and he's asking, Your Honor, to consider either a release to a treatment program, or that his original bond be reinstated with him attending treatment in the community. He is a parent. He and his significant other reside together. They have 2 children and 1 on the way. He does have his own business that he works, so he helps support the family. And I believe that his child that is due within the next couple of weeks. So he is asking really very much for an opportunity. He is to be able to do some sort of treatment if Your Honor believes that's appropriate, but with his first choice, if
Is he
Your Honor would
admitting to
consider.
this violation or not?
He's indicating yes.
He's admitting to the violation of using cocaine.
Yes.
Okay. I will give him a bond. I'm not giving him a PR bond, but he wants released to treatment.
Yes. Yes.
What kind of treatment was he in before he was taken in? What was he doing besides using?
I was going at his daily reprieve. It's called Catholic Child. It's a substance abuse. It's a substance abuse treatment. There's 2 different types of treatments.
Okay, Your Honor, he's indicating that he was involved with daily reprieve through Catholic Social Services, and that
Was he attending it?
I had to go the same day I had court.
so let me, okay, so that was what I was trying to ask you. Okay, so Your Honor, I actually have more information on that. He does have a pending matter out of 14A4. And as part of the pre-sentence things for him to do, he was to go to daily reprieve or to have an assessment for treatment. He was scheduled for that the afternoon that he was here last week.
So he has a case pending out of 14-4. What kind of case is that?
It is a use of substances.
Okay, and he was supposed to then have an assessment didn't get to that assessment.
Yeah, that is correct, because he was incarcerated that.
So I don't have anything in place.
That is correct. because
So
he was-
why would I let him out?
Well, he had the appointment scheduled, and it was for the same day as the court last week. We are hopeful that he can get him scheduled again so that he can do that assessment. He is scheduled to.
They won't come to do the assessment there in jail?
No, they will not. Mr. Brown is representing him on that matter, and it's my understanding they will not.
Have 14-4 seen this report
Mr.
with the cocaine?
Jones is indicating that they have.
When was the last time he was in court at 14-4?
Last week.
And so now they've seen this. What's his bond on that case?
It's on a PR. He was scheduled for sentencing and referred to get an assessment in Lenawee County where he resides.
Correct.
And he was arrested before he could obtain. He's scheduled for sentencing in JIS.
I think it's April 24th or 23rd, something like
Do
that.
you have proof of his appointment?
Proof of his assessment.
Yeah, when was that set?
I'll get my computer.
I'll pass this matter. You can take him back because my inclination is not to let him out, but I'll take a look at whatever you got.
Troy Gaines, Senior Assistant Public Defender representing Mr. Jones. You had requested verification that Mr. Jones was scheduled for a substance abuse evaluation last week, March 14th. Mr. Jones was in fact scheduled. I was able to obtain verification showing that he had an appointment on March 14th at 12 o'clock noon. With the testing agency, pardon me, with the assessment agency.
Okay, and I see that, but and they won't see him.
That is my understanding from Mr. Brown. That's the agency. That's one of the agencies, according to Mr. Brown, that 14
When was he set
days
for sentencing?
I want to say April 23rd, or was it the 22nd? April 23rd.
He was, no, I know when he set this time, but when was he was going to do the assessment, when was he set for sentencing after that assessment?
23rd. So in about a month.
Defendant having admitted to the violation, I'm not going to give him a straight PR. He'll need to set the appointment. I'll let him out prior to sentencing. I'll sentence him on that on the violation of 28 days. I'll give him credit for 21 days. So I'll serve an additional 3 weeks. He should get it out in time then to do his assessment and then properly be sentenced before Judge Freshour.
Right. Thank you.
What appears at first to be a routine courtroom. Hearing slowly turns into a tense and emotionally charged legal battle where confusion, addiction, and responsibility collide head-on. The proceeding begins with an unexpected issue when defense counsel informs the court that critical discovery files, including police reports and lab test results, are corrupted and unreadable, a problem echoed by the prosecution as well, forcing the defense to request an adjournment to ensure fairness. But the heart of the case quickly shifts to Mr. Jones, who has been remanded on a bond violation after allegedly testing positive for cocaine, a claim that becomes deeply contested when the defense presents conflicting evidence. 2 drug tests exist, one from a county facility indicating a positive result, and another test brought by Mr. Jones himself showing a negative screen. Both reportedly taken under observation but administered differently by different agents using different testing methods. The judge, cutting through the explanations, bluntly asks which test should be believed, emphasizing the court's reliance on official procedures over personal claims. As the discussion continues, it becomes clear this is not an isolated incident. Mr. Jones' record reflects repeated positive tests over time, a pattern that significantly weakens the defense's argument and reinforces the seriousness of the violation. Yet the defense pivots from technical disputes to a deeply human plea, painting Mr. Jones not just as a defendant, but as a father, a partner, and a provider who lives with his significant other, supports 2 children, and is awaiting the birth of another child in just weeks, all while running his own business to support his family. The argument is simple but powerful. Continued incarceration will not only punish Mr. Jones, but destabilize an entire family already under strain. The defense requests release to treatment, explaining that Mr. Jones had already taken steps toward rehabilitation and was scheduled for a substance abuse assessment, an appointment he missed only because he was jailed before he could attend. Documentation eventually confirms that the assessment had indeed been scheduled, lending credibility to the claim that he was attempting compliance. The emotional weight of the moment peaks when Mr. Jones admits to the violation outright, a confession that shifts the courtroom atmosphere and removes any illusion of denial. The judge responds firmly, making it clear that accountability cannot be ignored and that a personal recognizance bond is off the table, but also acknowledging that, untreated, addiction will only lead to repeated violations. In a measured but stern ruling, the court denies immediate freedom, yet opens a narrow door toward recovery, ordering a limited period of incarceration with credit for time served, followed by a structured release allowing Mr. Jones the opportunity to complete a proper assessment and engage in treatment before sentencing. The decision is neither lenient nor merciless. It reflects a justice system struggling to balance punishment with rehabilitation, evidence with empathy and public safety, with human reality. As the hearing concludes, the message to Mr. Jones is unmistakable. This is not just a legal consequence, but a final chance to choose accountability and recovery over relapse. And whether he succeeds will determine not only the outcome of his case, but the future of his family and his freedom. If you believe rehabilitation should matter as much as punishment, hit like. If you want more real courtroom moments with real consequences, subscribe and comment below. Should courts focus more on treatment or stricter punishment? Your voice matters.